हेलो। हाँ जी भैया। हाँ जी, हाँ जी। आप कहाँ पर हो अभी? ठीक है, ठीक है। हाँ, हाँ, कोई नहीं, मेरी भैया मीटिंग है 5:30 तक, तो मैं वैसे भी नहीं आ पाऊँगी 5:30 से पहले, पर मैं फ़्लैट में आ गई, तो आपको वेट करना पड़ेगा आधा घंटा। ठीक है। हेलो। हाँ, हाँ। क्योंकि उन्होंने कॉल करा ना अभी-अभी, अपने आप। बाय। हुँ।
Good evening, students. Am I audible?
Yes, sir, you're audible. Good afternoon, all. I, Asra Julka, welcome you all to session in the series of 5 introductory sections on different facets of media, conducted by Mediation Cell, Faculty of Law, University of Delhi, titled as Introductory Section on Mediation. With immense pleasure, I would like to introduce the speaker for the day, Dr. Ashish Kumar, who serves as Senior Assistant Professor over 10 years of teaching and research experience. Welcome you, sir. He is
Good
trained
evening.
as mediator with the training being accredited with American Bar Association. His doctoral research is a comprehensive study of the emerging domain of mediation in India. His principal areas of teaching and research are international law and law of the alternative dispute resolution. Currently, in addition to his teaching responsibilities, he is also discharging his duties as a deputy dean in the Office of Dean, Academic Affairs, the University of Delhi. Mediation is a process wherein the parties meet with a mutually selected, impartial, and neutral person who assists them in the negotiation of their differences. Now, I would like to invite Dr. Ashish Kumar to share his insights on the topic. Meanwhile, if you have any questions for our speaker, you can keep posting them in the chat box. So, over to you.
Um, Thank you, organizer, for this opportunity extended to me. Am I audible, students?
Yes, sir, you are audible.
So I think a sizable number of students have joined this session. So we can now begin. Time is very precious. So thanks for the nice introduction, student. Uh, and thanks for the organization of this much needed, you know, session on mediation. And I hope that this cell and the title, the name of this cell is itself mediation cell. So it is of course going to be involved. It is going to be involved much more into the emerging domain of mediation. And I understand that this is a very innovative, creative process of dispute resolution. And the students of law must make sure that at the end of their law school or 3-year LLB degree, they should be, you know, at least reasonably trained in the art and science of mediation, which promises a lot, which promises a lot in terms of, you know, bringing harmonious dispute resolution system in this country. And this is uh, this is being said that litigation, for example, is not the exclusive system of dispute resolution, and it must be supplemented with some other forms of dispute resolution. A critique has also said that if we go by the current data in Indian judicial system, which is which says data has proven that there are like 4 crore cases pending in this in our courts across the country. So with the current disposal rate, somebody has said that with this current disposal rate, it would take around 320 years to dispose of the existing areas of cases. That too, if no new cases are filed. So now you can imagine the extent of the problem which the judiciary in India is facing. We can't blame the judiciary alone. Of course, the executive, the government has also do a lot more in terms of providing and improvising and renovating infrastructure in this country, because only less than 1% of the GDP is spent on our judicial system. So with this introductory understanding of the importance of this branch of dispute resolution called dispute resolution through mediation, we can now proceed to understand certain basics of this alternative dispute resolution process. Now, when we speak of alternative dispute resolution process, it's it is not only it is not to be viewed in terms of arbitration or in terms of lok adalat, or in terms of other forms of hybrid methods of ADR, but it is also about understanding ADR in terms of parties' participation in any such ADR process. So if you will see arbitration on one hand, the parties have not much say so far as decision making is concerned. While this method of ADR, that's mediation, it allows for the parties to fully participate in the decision making process. So in that sense, it is a very democratic process of decision making. We'll come over to that later on. But first of all, let's understand some of the preliminary information about mediation process. So mediation has existed in almost all the ancient cultures of the world, be it Chinese culture, be it our own Indian culture, or Greek civilization. There has always been a system very akin to or relatable to mediation existed. In Indian Sanskrit scriptures, mediation has its etymological root in a term called madhyasthata, which literally translates into to see, to put things into two, or to half, or to make something half. So it is about balancing our approach. It is about ensuring that the parties do not occupy a particular position, and from that position alone they should not try to resolve the dispute. They should see things in perspective also from the other side, which which in a way is not the characteristics of other dispute resolution methods. So it has existed in almost all the cultures. Now you can ask, like, what is new about this process? Why is it all of a sudden emerging all across the world in all the legal systems? We now see more often people are talking about mediation. What's the reason for that? So to that, you have to go back to 60s and early 70s, when in the United States there has been vigorous talk, very passionate talking about the state of affairs which prevailed back then in United States. Like, a state of affairs meant undue delay in the resolution of case, in the litigation process, litigation suffering at the hands of the justice delivery system. So they, in the 60s and 70s, United States became very proactive. Professors there, the jurists, they all came together and advocated for making mediation mainstream. So that is the modern point of time when the mediation started to be seen as a very good mechanism, alternative to the litigation. Arbitration has always existed in almost all the legal systems, but arbitration, if you will see, it's more or less very relatable to the litigation process. And in arbitration, the arbitrator basically decides the dispute, and on the basis of his decision, an arbitral award is made. So one party loses and the other party wins. Parties have very little say in the matter of in arbitration process. So the jurists back in the early 70s, that particular point of time when the US professors and jurists came together, that they launched this Pound's conference. Roscoe Pound, in the name of Roscoe Pound, the former dean of the Harvard Law School. In his name, this Pound conference was organized, and everybody was concerned, what is the future of litigation? what is the future of dispute resolution? What would happen to all these cases, and should there be endless, should the state not worry about the extent of the judicial areas plaguing their court system? So the modern origin of the mediation can be traced to the Pound Conference, which happened in the United States. And from there onwards, the modern, practice and process of mediation started getting exported out of United States to the other parts of the world. And therefore, other jurisdictions like United Kingdom uh, and other developed legal systems, in particular European Union, in the 1990s, they also deliberated upon the state of affairs so far as their civil justice system was concerned. One thing I want to make clear here at the very outset, that when we speak of mediation, it has to do mostly with the civil cases, and only in exceptional cases that the mediation could also be applied in resolving criminal cases, only petty criminal cases. So it has mostly to do with the civil cases. So all the civil system in all the countries have been plagued by delays, undue delays, and excessive cost, with exorbitant number of civil cases being filed regularly in the court. So these were the reasons countries around the world became very thoughtful, and they wanted to implement the mandate of the Pound Conference, which was the outcome of the United States Pound Conference back in the 70s. So they exported this system to many parts of the world, and in India, in the mid Justice A.M. Ahmadi, when he was the Chief Justice of India, I think in 1995, he also became very thoughtful of bringing about radical reforms in the civil justice system of India. So in the 1995, if I'm reminded correctly, Justice M. Ahmadi sent lawyers team, which a team composed of lawyers and judges, to San Francisco to study to study the causes of delay in the justice system. And when that team came back to India, they recommended reforms in the civil justice system, which ultimately resulted into radical reforms, amendments into the CPC 1908. In 1999, the CPC amendment was made, and this Section 89, new renovated Section 89, was introduced, which now legally mandate the parties to explore mediation as one of the options of dispute resolution, ADR method. Mediation is now being mandated. So courtesy this team which went to San Francisco to explore the delays in the justice system, what plagues the civil justice system. They came here and they recommended, radical transformations into the civil procedure code, which ultimately culminated into 1999 amendment to the CPC. So now you can see what are the changes brought into it. So therefore, this is, I don't want to get into those legal or legalities of it. I would like to stick to the introductory part of the mediation. So basically, now I'm going to tell you about what are the principles of mediation, what is it exactly, how it is defined globally, what is the standard definition of mediation, what are the advantages, the disadvantages, benefit, and what is its application, in which area the mediation is useful. So therefore, let me so my session will be like 45 minutes more, and after that you will have the opportunity to raise questions. So after this introductory, very brief background to the idea of mediation, and now I'm going to stick to to the principles of mediation. So can any one of you tell me, what do you make of this term mediation? How do you define it? Students? Yes, Gauri Bansal, you can go ahead.
It's like reaching a common ground.
It's like meeting a common ground. Okay. What else? Anyone
Sir,
else?
not going through conventional ways of getting justice. The party is getting hurt or something,
Hmm.
but instead of that, going to another person or to a person whom we know each other, who could be possible appointed by a court, uh, and seek justice from him. Not going through conventional ways.
So just tell me one key characteristics of it. Like she said, you know, just tell me one crucial characteristics of this process.
So it is an informal process.
Yeah, very good. Informal process.
That both the parties are in front of each other and telling about their grievances, and that is not in front of a court.
It doesn't happen in front of the court. Rightly pointed out.
And decision is not bound on the parties. They can still opt for the another remedies.
Fantastic. Decision is not binding on the parties.
And so there's a neutral party that is conducting a mediation.
Yes, the neutral party. Neutral party or I mean the third person.
Third person, neutral third person.
Neutral third person. Fantastic. You have rightly pointed out you have rightly observed key characteristics of this process. Um, so therefore, it is important that you understand how mediation is seen across the globe, because it's not about how Indians define mediation or Indian law defines mediation, because mediation is now a global phenomenon. The role of the mediator should remain the same if you happen to participate in an international commercial mediation. You must understand how the role of the mediator in that context, in that setting. Now, having said this, it also means that the parties themselves can customize the role of the mediator. But then there are some fundamental characteristics and features, the roles of the mediator, which cannot be compromised. Even through customized agreement between the parties, it's not possible. So therefore, it's important that you make sense with the role envisaged for the mediator, and then you also should make sense with the idea of the way the process unfolds, the rights of the parties in the mediation process, what transpires, what happens inside the mediation chamber. So first of all, I wanted to share this slide with you. Is this visible, what I have shared?
Yes, sir.
Okay, so now I can proceed further. Yeah, so I will come to the 5 principles of mediation. So now you got to tell me, what do you make of neutrality and impartiality? Because these are the 5 elements or principles which must guide any mediation process. I will come to the definition later. First of all, let's understand, because in that definition, these elements must be present. The last element I have added to that list, but let me ask you, what do you make of the first principle, neutrality and impartiality?
So the whole process should be neutral and impartial, not favoring any party over the other.
तो ये क्या इन दोनों में डिफरेंस क्या होता है? Neutrality of the mediator, how is that distinct from impartiality of the mediator?
So
The
neutrality
neutral
is
as in, as in neutral means no preconceived ideas, and impartial means no bias for any party.
Now, how you can objectively determine that somebody is neutral?
No relationship or no any not in connection with any party.
Yeah, it's an objective parameter. Always remember, neutrality, when we speak of mediator's neutrality, it means he's not going to take any side. Okay, and in order to further determine that he must not take any side, you can further raise this question before the mediator: are you in any way related to the party, or either party, or both parties? Like, of course, if it is related to both the parties, then there is no question of him having compromised his neutrality. But if he's related to either party, and if he does not disclose that fact, then he has compromised. Impartiality is more objective, and it is about mediator, or like any individual. When we say an individual is impartial, it means he's to remain or stay totally fair and just towards all parties involved. So it's little subjective in nature. So this is the distinction between impartiality and neutrality. So, so therefore, this is the first principle of mediation, that the mediator has to remain totally impartial and neutral. Like, in relation to the first, that is the neutrality of the mediator, you have the right to raise this question, as I just said. Now, in the Mediation Act, I don't know whether Mediation Act has provided this list or not, but in the Arbitration Act, you will see in Schedule 5 of the Act, added to the Arbitration Act in 2015, a very comprehensive list or of scenarios or situations whereby you can determine that the arbitrator is neutral or not neutral. Like, it lists out all those scenarios, including a scenario, for example, like if the arbitrator happens to be a manager in a firm owned by one of the parties, for example. So that list is provided in the Arbitration Act. We have to check out whether the new Mediation Act provides that list or not. So this is very vital. And once in the mediation process, the mediator has to make this point very clear that either party is not related to him, or even if either party is related to him, that fact he must disclose in order to make sure that he receives an informed consent of the parties. If he does not do that, he has compromised his neutrality. Impartiality, that particular thing you can observe all through the process, how much he is fair, or how much he is unbiased. So this is the kernel of the process. To establish neutrality, the mediator has to say something, state something in his opening statement and throughout the process. One of a most often an often cited example in this context is like when mediator asks both the parties in his mediation chamber to sit nicely on chair, okay, and he leans towards one particular party favorably, or he closes the gap between his chair and a particular party's chair. So this is something which can create doubt in his neutrality, so that he must avoid. So that can happen through training. In training, all these things are made clear, and the trainee is supposed to observe uh, all these characteristics of a true mediator, neutral mediator. So this is the first principle, neutrality and impartiality of the mediator. In short, we can say impartiality is freedom from favoritism, bias, or prejudice. The next principle which I have noted in this yes, voluntariness. मतलब मैं आपको बता रहा हूं कि these are the principles of mediation which must be present in any mediation process. Voluntariness, what's that? The student, what do you make of this voluntariness?
So both party are voluntariness for this process. They are no forced to take this method, mediation method.
Okay. जब हम कहते हैं कि मीडिएशन प्रोसेस में वॉलंटरीनेस होनी चाहिए, तो व्हाट डज इट मीन? And what do you make of this term, voluntariness?
Sir, means a person comes to mediation of his own free will without any like force or pressure.
Yes, fantastic. What is the opposite of voluntariness?
So involuntariness, being forced.
It legally speaking, we can say coercion. Coercion to settle, or pressure being exerted to settle. So voluntariness is one of the essential hallmarks of the mediation process. Now it has legal meanings as well. When we say the parties must enter the process voluntarily, it has two meanings. One is to be ready to participate, not to settle. I'm saying to be ready to participate voluntarily. It has two meanings. One is to participate in the process voluntarily, and to settle in the process with free consent, voluntarily. Now this voluntariness will end as and when parties have settled and they have also signed the mediated settlement agreement. So after that, that process is over. Later on, that mediated settlement agreement can be challenged in a court of law, just like an ordinary contract is challenged, that there was no free will, voluntariness. So, but that process, from the point of view of mediation process, that voluntariness ends as and when the parties settle and they also sign the mediated settlement agreement. Now, coming back to the two meanings of it, the first meaning of it, voluntariness in the first place means that the court under section 89, suppose if it is a court mandated mediation or court annexed mediation, आपको मैं बता दूं कि बहुत तरह के mediation होते हैं. एक तो private mediation, just like between X and Y, private mediation happening in a private chamber of mediation service provider, like you're a mediator, you also provide private mediation service, and parties have named you as the mediator in their dispute. And the other one is, that's called private mediation. The other one is court referred mediation, court annexed mediation, okay, court supervised mediation. सारे जितने भी terms हैं सबका मतलब एक ही है, court annexed, court mandated, court supervised. This comes under section 89 of the CPC. That means any civil litigation which is instituted in the court of law, the court acting under section 89 will ask the party to explore either of these options. There are 5 options mentioned, one of which is mediation. That includes arbitration, conciliation, lok adalat, judicial settlement, and mediation. These are all ADR options. Now, you can have a question like, what's the difference between mediation and arbitration? So I told you very clearly, arbitrator operates more or less like a judge. The only distinction is that the arbitrator is a private person, whereas the judge is a state appointed person. But there is vast difference between arbitrator's role and the mediator's role. So since I'm sticking only to the idea and practice of mediation, so you have to understand that mediation under section 89 means the court is hearing any civil litigation, and on the very first day the court asks the parties which option would you like to explore. So if the party says they don't want arbitration, the court cannot send the parties to arbitrate. That's it. If the party also say no to conciliation, then the court cannot send the parties to conciliate. This is the law settled by one of the leading cases on this area, that's called Afcon's case. Afcon's case decided in 2009. So that case has led down. It's a kind of Keshwan and Bharti for the area of ADR mediation in India. Just as the importance of Keshwan and Bharti for constitutional law, same is the case with Afcon's case so far as mediation in India is concerned. So coming back to the point, under section 89, the parties cannot be compelled to go to arbitrate or go to conciliate. But clarity was brought by the Afcon's case, and as per the mandate of Afcon's case, the party can be sent to the mediation center by the court acting under section 89. Now, if you have followed me just now what I have said, can you tell me, when the court acting under section 89 sends the parties to mediate, can the party ignore this and can say that they don't want to go to mediation? Student?
Sir, I think they would have to attend the mediation, but after a while they can say that mediation process is not working and they would still like to go to the court.
Yeah, fantastic. It means voluntariness means it is not about refusing to go and participate in the mediation process. This is what I wanted to tell you. With this example, the party doesn't have the option or choice to refuse to participate. And if you will see the new act, there is also the possibility of imposing cost if the party unreasonably refuse or even unreasonably refuse to settle. Now, this can create some jurisprudential controversies so far as principle of voluntariness is concerned. That we have to see. But this is the meaning attached to the principle of voluntariness. Party can be sent to the mediation process. They cannot refuse, but they can refuse to settle. So that is the core and the kernel of the principle of voluntariness. They cannot be compelled to settle. They have all right to come back from the mediation session and refuse to settle, refuse to sign. The mediated settlement agreement becomes binding only when that is signed by both the parties. So before signing, they can at any point of time come back from the process. So I hope that you make sense with the idea of voluntariness. The third principle is self-determination. What does it mean, student?
So, as far as I understand, it means that a party puts forward their own solutions and try to reach a common understanding. Like it's like they're actively involved in a decision making or solution resolving problem.
Yes, you have very rightly pointed out. Self-determination is the other way of saying that mediation ensures that the decision making rests in the hands of the party. or in other way, we can say party control of the decision-making process. Okay, now that is something remarkable in the idea of mediation. The fact that it offers decision making in the hands of the parties, that is something very remarkable, and we have to get into the literature to find out the genesis and the further principles guiding this self-determination in the mediation process. It's something remarkable, as I said. It also means that the participating parties should remain aware, should be vigilant, should have all information, all the vital information made available by the mediator before the process begins. So in his opening statement, the mediator must make sure that he has said that the decision making will rest in the hands of the parties. If he fails to communicate this vital principle to the parties, then it can cause controversy, or maybe later on this can even be a ground for challenging the mediated settlement agreement, that nobody knew what self-determination meant. So self-determination is very vital. It is, as I said, it is the kernel of the mediation process, one of the kernels, one of the core features. So now, when we speak of self-determination, sometimes it becomes quite far-fetched, unrealistic to always expect that the parties who are themselves quarreling or disputing would come together and settle favorably. What then will be the role of the third party mediator? So that's a very it's very much expected question. But it means that the mediator will not impose his decision. If the mediator starts imposing his decision, then this process called mediation does not remain mediation. It becomes something else. It may then be described as arbitration or litigation, but is not at all mediation process. So self-determination also reflects on the mediation process, in that it can, if it is compromised, self-determination is compromised, mediator does not say anything about self-determination or party controlling the decision making, then he is likely to operate himself as a judge or an arbitrator. And if that being the case, then the parties should not have explored this mediation process. They should have gone for arbitration or litigation. They are here precisely because this process called because this ADR method called mediation offers them self-determination. So, but having said that, since not all parties are aware about self-determination, or practically speaking, it's not always possible. So therefore, self-determination, this principle, can be customized by the negotiating parties, like X and Y entering into mediated, X and Y entering into negotiating for the mediation clause. At that very moment, they can insert that if need be, mediator can be given the power to evaluate the issues. And when we say evaluate the issues, it means that the mediator can give his own decision on one particular issue. So that is not the default. Default idea is that self-determination means that parties will remain in the driving seat so far as the decision making is concerned. But this can be further customized through parties' agreement. Okay. So in one particular US case, the mediator wanted to impose his decision and it was backfired on him. He was then charged with uh, mediators. There are mediators court available in USA, so he was charged with mediators malpractice. So this is very important that the mediator in the very first place tell the parties to the very fact that they will control the decision making, and the mediator is there only to facilitate the parties. Now what comes under the facilitate, just now tell you, it's not a very simple term. It has a very large meaning within this term called facilitation. So many practical tricks can be covered. So we'll come over to that later on. Self-determination, what is the role of the mediator, we'll tell you just now. The next principle of mediation is confidentiality. तो ये क्या होता है स्टूडेंट? What do you make of confidentiality of the mediation process?
Sir, it means it's private, classified, and what happens in a room doesn't leave that room. Like what we are discussing in a room, it should stay there only.
Fantastic. Anyone else?
So, like in litigation, the judgments and all are published, so everyone knows what happened. But here, that will not be there. As Rishi said, it will be only within the room and the people over there.
So this is something, this principle is what the parties are attracted for, looking for. Mediation confidentiality is, I would rate it as the heart and soul of the mediation process. Like, you can rate it yourself, but to me, confidentiality is something which goes to the heart of the mediation process. Without assurance of confidentiality of the process, no one or very few would ever venture into the mediation process. It assures the parties that things said, documents exchanged, utterances made shall remain confidential. That is to say, legally speaking, whatever said and exchanged in the mediation process will not be a ground for will not be used in formal adjudication processes. For example, not in the arbitration, not in the mediation. So because there is little state threat in the mediation process, because the mediators are appointed by the parties and the coercive element is almost negligible. If you will contrast mediation with litigation or arbitration, the coercion is very less. State coercion is negligible, non-existent. So this is what attracts the parties, that the mediation process will remain confidential, and whatever they will say here in this process will not be used in the formal adjudication process. Suppose mediation fails and that matter for which mediation was happening, but mediation became unsuccessful, and if that matter reaches the court later on, in the court, one party cannot say that this particular issue was almost settled in the mediation, or that the other side has said this or has admitted that. That cannot be done in litigation. The court will stop the party, or you as a lawyer representing the party in the litigation, and you know what are the principles of mediation, you can then and there stop the party. Please, my lord, it is a breach of confidentiality. Mediation was totally confidential, and now here that party is raking up the mediation, what happened in the mediation. That cannot be done. That process remain confidential. So, and it ensures in the mediation process, mediation being confidential, it means that the party will exchange views will exchange views, will utter words, will communicate freely, candidly, knowing fully well that whatever they will communicate, say, exchange will remain confidential. So that's a very big incentive for them to have a very, candid dialogue in the mediation process with the other side. If there be no confidentiality, then they will remain reluctant, and it will reduce the process as a mere fishing expedition. Somebody has said, if you don't have confidentiality, the party will come there and will just will try to figure it out, the strength and weakness of the other side. So if that becomes the case, then mediation as a system of alternative dispute resolution will fail. It will have no value, public value. Confidentiality is the hallmark. To me, it is the heart and soul. But some critique have also pointed out the limits of mediation confidentiality. What should be the limits of mediation confidentiality? Do you think that everything done, said, acted in the mediation's chamber should remain confidential in the name of mediation confidentiality? What do you think, student?
No, sir. Sir, I think if any illegal act is disclosed, it should be reported then.
It should be reported. So if a cognizable offense takes place, then that has to be reported. The mediator is the person who must report it. So that is not like you say in the mediation that if things don't go well, then I will kill the other person. That's something totally unacceptable. So therefore, that has to be reported, and that can not remain, protected in the name of mediation confidentiality. So there are many cases also in India. We have yet to see cases covering confidentiality. In some of the cases, the Supreme Court has merely pointed out that mediation is totally confidential, and whatever I just said was also established in the decision, Davati's case, or I'm forgetting that case name. So, but in USA, because in USA, as I said, right from 70s, mediation has been happening, and so they now have a good body of case laws covering all these features. Okay, so from USA, you can get many cases covering these principles. So therefore, there are limits to confidentiality. It is not absolute, but this is what we mean. It is something which provokes the parties, incentivizes the parties to explore mutual resolution of the dispute, with things being said, uttered in the process remaining confidential. That's the fourth principle. The fifth principle is dispute management. Now, this is something which I have added to the list, and which I always explain to the student by saying that, look, when we say dispute management aspect of the mediation process, it means, can you just guess what is it? How do you look at this principle, dispute management?
So it is like records, taking all the records of the data and managing in a way that so it cannot be misused in the future. So managing all the things of the records of the party and other things.
Okay. Okay, fine. Somebody else who wants to make a guess?
So basically, when a conflict arises between the parties and they seek a way to manage that, like mediation is all about that only, na? Dispute management. Whenever conflict arises between the parties and they are not able to agree on a single solution, mediation is the way to go. So that is
Yeah,
what is it
yeah. So
is.
that's the okay. So let me just further elaborate. Whatever you have said, that's right in the context in which you are saying. But the context which I am using this for explaining dispute management is this. When we say that mediation allows for dispute management, or this should be the objective of the mediator as well as the parties, it means many things. Either 100% solution. Okay, so that's something we can describe as a big success, But we parties should remain realistic. Mediator should also remain realistic in the process. It's not that the mediator and the parties only thinking in terms of 100% solution of their disputes. That's not realistic. We have to think in terms of managing the dispute. Okay, so like X and Y have 10 outstanding issues between themselves, then there is a realistic way of looking at the 10 issues. Your focus, or the parties and the mediators focus, should not be that all the 10 issues must stand resolved. It's about managing the scope of the dispute. Each issues may be related to each other, but some issues may not be related. So if you have between parties 10 issues, with dispute management in mind, it means the mediator attempting to resolve as many issues as possible. This is first meaning. Other meaning is that some issues, the mediator telling the parties, okay, we can mutually settle on 2 or 3 issues, and the rest of the issues can be, attempted to be to be to be resolved using other dispute resolution processes, including litigation. So therefore, mediation in a way helps the parties to manage the dispute. This is very vital. You as a lawyer in a future should think mediation as a method of managing the disputes, so that more serious issues, less serious issues could be mediated upon, and more acrimonious issues could then be referred to litigation or arbitration, as the parties, whatever the parties think. So this is something remarkable, because mediation gives you the hope that at least even if the parties, so it pushes the parties to go for mediation. Okay, we have like 5 or 6 issues, we can discuss and enter into dialogue and resolve some of the lesser issues. So this can be an incentive for the parties to explore this process. With communication, with dialogue, many things can be ironed out, many issues can be ironed out. So therefore, these are the 5 principles of mediation. You can stick to 4 principles. These 4 principles must remain present in any standard mediation process. Okay. So now what happens in the mediation process? So I can share my thought on that. I think 5 minutes on the mediation process. So after you have understood that these are the 5 principles, which the law must also, these 4 principles must inform and guide any policy and law on mediation. So if you have a law, in some countries they passed a law which like in Italy, a lot of controversies happened, erupted over a law on mediation, which said that in telecom disputes, the parties will be compelled to settle if the amount is of such magnitude. If the amount involved in telecom disputes, power disputes, sorry, electricity disputes, involves this much amount, they have to compulsorily settle. And then that hit the parties' constitutional right to approach the court. Okay, that was then declared unconstitutional. So therefore, because we all know that everybody has the right to approach the court under Article 21 of our Constitution, and similarly, it's a fundamental right to approach the court. Access to justice is something very fundamental in the legal system. So, in the name of settling disputes only through mediation, you cannot outrightly deny access to justice to the parties or deny the party fundamental right to approach the court. So therefore, you have to be, these principles inform you, these principles tell you that they must remain present in any mediation policy, in any mediation legislation, etc. We now come over to understanding the mediation process. So what I think generally it takes some time to make people understand the mediation process. In brief, I can tell you that while you approach, you understand how mediation can begin under Section 89. They can the in any litigation, civil litigation, the court finding elements of settlement, then referring the party to explore arbitration, conciliation, mediation, lok adalat, etc., judicial settlement. So after that, the case is referred to the mediator. Mediator appoints a date, gives the date to the party, and then the party is supposed to visit the mediation chamber and participate in the process on the given date. So there, on the first date, the mediator in his mediation session is supposed to make a very powerful opening statement. So therefore, at this particular point of time, I can tell you, you can make some homework if you are interested into this idea and practice of mediation. You can think about making your own opening statement. Opening statement sets the tone for the mediation process. And as I said, in the opening statement, whatever the mediator will say, every opening statement of the mediator will flow very naturally, will be composed by the mediator himself or herself. But in the opening statement, these four elements must remain present. Okay, like the process is confidential, the process is voluntary, the process allows for the parties to retain control of the decision making, or the process is confidential, and that his role is neutral and impartial, etc. Okay, so that is the opening statement. After the opening statement is made by the party, by the mediator then asks one party to narrate his or her side of the story. So in this context, can I ask you, which party will be called up by the mediator first? Because you have to understand that mediator should not show undue inclination while he is inviting a party. So the second party might think that why that person is being invited first to speak, why the other side is being invited first to speak. So what do you think? Whom the mediator should invite first? What is the objective criteria?
Sir, I think one who's the complainant.
Okay. वन मोर थिंग, क्योंकि उसके लिए तो अलग से बड़ा लेक्चर चाहिए होता है. मीडिएशन में जो लैंग्वेज है वो लॉ का लैंग्वेज नहीं है, एटलीस्ट इसलिए हम कहते हैं कि जो लॉयर, देयर इज अ कंट्रोवर्सी, रेजिंग कंट्रोवर्सी अराउंड द वर्ल्ड that whether lawyers make a perfect mediator or good mediator, because the lawyer and the judges are very prone. They have the advantage that they know the law, but so far as the language skills are concerned, the mediator, the lawyer mediator and the judge mediator, they are very prone to using all kind of legalese, legal maxims, and using all the time legal language, legal words. So any such legal word can can compromise the neutrality of the mediator, the impartiality of the mediator. For example, if the mediator in the instant case says, okay, the first party um, I mean, communicates to both the parties, okay, X, who is the complainant, should now make his opening statement or should narrate his or her version of the facts. So he has already passed a judgment that who is the complainant. He has not yet heard entire facts and he has already passed a judgment that he is complainant. It means he recognizes the fact that somebody is aggrieved. So he has to avoid legal jargons. So that's why the training program also involves. Uh, it's not possible overnight, but with training and with experience, a mediator becomes skillful insofar as the language of mediation is concerned. So he can say, he can simply call, if the name of the X is John, so he can say, okay, John can, if the other side allows me, then John can make the opening statement. Uh, so, and thereafter the second party will say. Now, during such unfoldings, the mediator has to make sure that both parties are not mutually accusing each other. That happens, of course, that happens all the time. I have seen all the time it will happen. But this is the task of the mediator to make sure that both parties are not using bad words or swear words, hurling abuses against each other. That should not happen. That's why the mediator task role is to set the ground rules and tell the parties clearly. Both parties would be using, would not be using these words, bad words or cuss words, and would rather remain polite and civilized. Okay. Uh, if the if such accusations are being made against each other violently, there is a possibility of verbal violence or even physical violence outbreaking, then in that case, the mediator will stop the process then and there. Now, the mediator opening a statement is then followed by parties opening a statement. And after the parties opening a statement, there can be series of sessions. Okay. Two particular types of sessions. One is called joint session and the other one caucus or separate session. In America, separate session is called caucus. Joint session, we can understand very easily that in the joint session, the mediator uh, allows the first party, to elaborate further, to address, to to be able to identify the issues which the parties have. After the mediator has heard both the parties in the joint session, the mediator can identify the issues and he can then confirm whether he has correctly identified the issues or not. Okay. So these days, storytelling or narrative mediation is also becoming popular in some jurisdictions like USA. So mediator, it is being said that mediator should be a very good storyteller and good narrator. But that apart, in the joint session, mediators' storytelling skills can also be used to dig out the issues. What the mediator in the joint session is supposed to do, basically, after identifying the issue, the mediator task is to move the parties away from their positions and allow them to focus more on interest. Okay. Now you can have question. What do we make of position and interest? So position is the party. Position is what the party occupies. Like when a party X says, Y has taken money from me, has taken 10 lakh rupees from me, and he has not returned that money. Okay. So his position is entirely to get back the money. Okay. 10 lakh rupees. So the position, if the in litigation, the parties are only allowed to plead from their positions. Interests are what lie beneath the position of the parties. Okay. Now, in order to understand what do we make of position and interests, let me share You can Google it yourself. I don't have the time, or time is running out. You can Google it yourself. Just the keyword is conflict iceberg. Conflict iceberg. Conflict iceberg को आप Google कर लेना. वो that will give you a very fundamental understanding of the difference between position and interests. So behind each position of the party, there is an endless, amount of interests. Interests are the reasons behind the positions, we can say. Those reasons could be like X did not ever acknowledge the X never Y did not acknowledge the existence of grievance in X. Acknowledgement is also very important. Tendering apology is also very important. Or extending respect. So all these human elements can get covered when we speak of interest behind the position of the parties. So that is something which the mediator is supposed to dig out. To understand issues will only give mediator the sense of parties' positions. So parties' interest, a particular party's interest behind a particular position is not likely to be revealed in the joint session. Hence, the mediator will then fix separate session with the parties. So this joint and separate session will keep on continuing till the both parties allow for it, because the party, as I said, can come out of it anytime before signing the settlement agreement. So therefore, this is what we mean by mediation session. कि आप कोर्ट में जब उधर जाओगे समाधान सेंटर हाई कोर्ट में, तो वहाँ बोलेंगे कितने सेशन हो गए, 5 हो गए, 10 हो गए. तो इसमें यही होता है. एक बार आप ज्वाइंट सेशन करोगे, तो ज्वाइंट सेशन में बेसिकली व्हेन द पार्टीज बोथ पार्टीज agree for joint session, it means both parties are open for discussion on some issues. And when we speak of caucus or separate session, it means parties, one party is reluctant to share information in joint session in the presence of the other side. So the caucus is a very important tool for digging out the interests of the parties and for communicating what first party thinks about the resolution. So therefore, with this, I will end so far as mediation process is concerned. This joint session caucus is then followed by deal making negotiation, which is again sort of joint session where both parties come and in the presence of the mediator, not in the presence, like mediator starts noting down the settlement terms or the terms of the settlement between the parties. And after all the terms of the settlement are reduced into writing, then the mediator asking both the parties whether they have understood or not, and if they have any further issue, they can raise it then and there before signing the settlement agreement. So this is what we mean by the various stages of the mediation process. There are not very too many stages. It's like after the opening statement by the mediator and the party, the mediator then considering various mediation sessions, which could either be caucus or joint session. There is no hierarchical order like which should come first. It all depends on the context and the mediator telling the party to explore options for resolution in either in joint session or in caucus. So there is no particular way of conducting joint session. It's not hierarchical in that sense. Now, when the mediation ends, then there is the closing session. If it is successful, then the mediator thanks the parties. Okay, a mediator can tell the party, can congratulate the party, and can tell them thanks for their participation and thanks for hammering out a deal. If the mediation is not successful, then still the mediator has to construct a very good closing statement. Now, I leave it to you to think about what should be the content of mediation closing statement, if the mediation was successful, and if what should be the content of the closing statement if the mediation was not successful. Okay. क्योंकि उसमें उसको ये भी है कि भाई अगर अनसक्सेसफुल है तो he has to mediator has to see his own prospects as a good mediator. Okay, so mediator generally in an unsuccessful mediations tells the parties, thanks for your participation, thanks for your patience and time, and it is both of you have not agreed. That doesn't mean that that fact should deter you from exploring mediation in future. Okay, and at any point of time, if both parties do make a change of mind, then it is that forum where they should come back again. So somehow mediator wants to be optimistic and ends on a very optimistic note. So this is what we mean by the mediation process. Okay, now we are left with only 12 minutes. So let's deal with the role of the mediator. As you can see, there are various roles of the mediator. मैं आपको अगर मीडिएशन में इंटरेस्टेड हो तो एक just hold on, I am just forgetting the name of that mediation expert. I think Badger. Yeah, Badger. This is the role of the mediator. I can just share here in the group in the chat section. So you can see in the chat section, Badger stands for the it basically reflects on the role of the mediator. The mediator is the one who begins the mediation process. Role of the mediator, Badger, BADGER. This tells you the various roles of the mediator. So this is a very good acronym to remember the role of the mediator. So he is the one who begins the mediation. Okay, and A stands for accumulate facts and information about the parties and about the dispute. D stands for define the issues, develop an agenda to empower parties to reach a resolution. Okay. So he defines the issues and develop an agenda. Agenda is more processual in nature, more procedural. It's not like giving his own view. This is how the mediator thinks about, thinks about resolving the issues. It's more processual in nature, like using pen and paper, using whiteboard, and asking the party. Using pen and paper, using whiteboard. Reversal technique. This is very powerful technique. So this is what we mean by generate change in position. E stand for escape to caucus. If the joint session is proving to be unfruitful, unmanageable, then immediately, terminate that session and ask either party to go for caucus. Caucus means session happening between joint session means mediator having joint session means mediator having session with both the parties in a big chamber where both parties are sitting together. And mediation caucus means mediator having one-to-one session with either party. And R stands for this: resolve and write up the settlement memorandum for the parties to execute. So this is a very simple way of this was given by Stuart Stultberg, whom I also had the opportunity to meet while I was being trained in mediation back in 2014. So Joseph Stultberg has given this acronym. Now you can see these are the benefits of mediation. We have already discussed those benefits: confidentiality, voluntary, control, win-win. It says, but in order to have a good understanding of mediation, you also should have very good grounds in understanding art and science of negotiation. So just buy any good standard book on negotiation and start reading it. Negotiation is the foundation for mediation. Okay. So in sixth semester, we do teach negotiation first, okay, but not in detail. Only introductory things are discussed in the class, 6 or 7 lectures for negotiation. But even otherwise, this is a life skill. Negotiation, mediation are life skills. Even if you don't want to practice law, you have to develop good sound understanding and knowledge of mediation, negotiation and mediation. This is a life skill. This is something which will add to your CV a lot. So these are the benefits which you all know. It is cost effective, efficient, confidential, constructive process, and very vital. This can help parties preserve relationship, okay, avoid legal battles, and craft creative solutions. And one very essential idea about the utility of mediation is this: that since the parties are themselves signing the settlement agreement, they have very little choice to deny the legitimacy of what they have signed. And it will not be very easy for the party to prove it otherwise. Like in the next time after signing the settlement agreement, either party takes up challenges that settlement agreement in the court of law, then it will not be very easy unless and until there are sound witnesses present, because the proof the threshold of proof is very strong if you want to prove it otherwise, that your consent was not of free will, for example, or that you did not want to participate, or that the mediator did the mediation very badly or compromised with the mediator's code, etc. So therefore, whatever you will agree to. So it means ultimately, I often cite this example, like that if you have, like in civil litigation, you have first appeal available, in some cases second appeal. Okay, only in rare cases second appeal is allowed. So litigator in a civil action usually explores all the appellates, and then you have review, revision, all these things available in the hands of the litigating party. So with mediation, at least you can say that since parties have themselves hammered out a deal and signed that deal, so even if either party decides to challenge that settlement agreement, that that party is not likely to explore all the appellate and revision and review processes. And also it's very difficult to prove it otherwise, as I said. Now, based on all the discussions we have, now we are going to define the definition of mediation as found in the Delhi High Court Mediation Rules 2005, and also in the Act, newly passed Act. Okay, so that you start making sense with what we have discussed and whether those aspects are covered in the law, in the legal definition of mediation or not. So first of all, can you see, student? Rule 16 of Delhi High Court Mediation Rules 2005. Can you see it?
Yes, sir.
Okay. तो इसको पढ़ो. Read it. Anyone?
Sir, should we read it aloud? Like, are you
Yeah,
asking?
read it aloud because it's getting one-way communication.
Okay. The mediator conciliator shall attempt to facilitate voluntary resolution of the disputes by the.
Speak slowly.
Okay.
Yes.
The mediator conciliator shall attempt to facilitate voluntary resolution of the disputes by the parties and communicate the view of each party to the other, assist them in identifying issues, reducing misunderstandings, clarifying priorities, exploring areas of compromise, and generating options in an attempt to solve the dispute, emphasizing that it is the responsibility of the parties to take decisions which affect them. He shall not impose any terms of settlement on the parties.
Okay. Now you got to tell me which fundamental principle you find you think present in this definition. What are the fundamental, whether the fundamental principles are captured by this 2005? You mind it, this is Delhi High Court Mediation Rules 2005. uh, this was created by the Delhi High Court because the Malimat Committee, just a small background, in 1999 the new section 89 was introduced, which allows for mediation for civil disputes in the first place. So against that, the lawyer went on rampage across India. They said this will hit them very hard, okay, because mediation they were not exposed to, so they resented the idea of mediation. After that, controversy emerged, and in Supreme Court, in the Salem Advocate Bar Association, constituted a committee, Malimat Committee, and Malimat Committee put forth this mediation rules, which was then adopted by all the high courts. So in each high court, you will see mediation rules. They are all the same. Okay, no change. Only that it's Punjab and Haryana High Court mediation rules. This is Delhi High Court mediation rules. No change. So this was the ad hoc, law, in a sense that it was not a properly parliamentary made law. It was it was adopted by, because the Supreme Court adopted the asked all the high courts to adopt the Malimat Committee's mediation rules, draft mediation rules. So now, since we have a full-fledged law that's called Mediation Act of India, so we will see how mediation is defined just in the next slide. So just let me ask you, how do you see this definition as? Whether all the elements are reflected, all the principles are reflected?
Yes, sir. All the elements, characteristics that you mentioned are reflected in the definition.
Okay, so this is a very good definition. Almost all the elements are covered. A mediator, but it is also applied on conciliator. There isn't much difference between mediation and conciliation. There isn't. Okay, only the default understanding of conciliation is that in conciliation, the conciliator can even start giving his own views on each issue, which the mediator in the default mediation does not allow. In default mediation, the mediator will not give his own views as to how the dispute must be settled. Like, he cannot have his own judgment on each issue. But in conciliation, the default understanding of conciliation, conciliator's role is that to conciliate. Only this much difference. Otherwise, both processes are totally same. So many, I think this term conciliation will also be removed, and wherever the term conciliation is used in our law, that will be taken also as mediation. So that's why the slash is used here. So you see, now we will see how Section 4 of the new Act has defined mediation. So have a look at it, read it aloud. Any other student? Sumit Daya?
Yes, sir. Section 4. Mediations shall be a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby party or parties request a third person, referred to as a mediator or mediation service provider, to assist them in their attempt to reach a amicable settlement of a dispute.
Yeah. So this is the standard definition which has captured the essence of the mediation. It does not clearly reflect. Now you will have separate provision on confidentiality also. Okay. So So be mindful of Section 4 of the new Act, which defines mediation, which shall be a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression. So this is a very big achievement because conciliation was creating a lot of confusion. Now that has been done away with in the new Act. So, and there is a third person referred to as mediator or mediation service provider. What does it mean, mediation service provider?
So refer to a firm which provides the service of mediation.
Yeah. So there are many firms or there are many institutions like in Western law schools, even the law schools provides mediation services to the needy clients. So like your mediation cell, if it is evolved and if it is made, if it acquires its name and becomes an institution itself, then it will start uh, providing mediation service to the needy people. Okay. Last thing, just in 2-3 minutes, I will wind up, which is also important in this introductory session as to what should be the and so application kya hai? In which area you think now at least we should know some limitations of mediation. It's not like everything is rosy when we think of mediation. It is not the case. Everything should be critiqued, just like litigation is critiqued. Similarly, this process also needs to be criticized for some inherent issues or some inherent weaknesses. So, but before that, let me just ask you, what are the applications of this? In which area you think that it should be used?
So mostly in the civil side, the consumer disputes, property disputes.
This is going to be hugely important area. It has already become. Even in mediation, you can only think about specializing in some areas. So application of it, you should. Am I supposed to allow or Satyam Dwivedi is asking? So just before we end, and what are the areas in which you think uh, mediation is applied or mediation has got an application? So there are many areas. Mostly it began with its application in family disputes. So that area became family mediation. Broad, overarching category of disputes where mediation is applied is called civil mediation. Civil mediation. Another big term describing the category of cases fit to be mediated on is commercial mediation for commercial disputes. Family mediation for family matters. In labor mediation, dealing with the labor issues or labor um, whatever arising in the industry. So that is described as labor mediation. Or another one, many disputes arising at the workplace Some has described that mediation as workplace mediation. Labor mediation can also be equated with employment mediation. In criminal area, in limited number of cases, mediation is applied, especially in petty offenses, and that called victim offender mediation. Victim offender mediation, which is a little, relatable to plea bargaining. Not really plea bargaining, but it has got connection with plea bargaining. So victim offender mediation means applies in the criminal cases. Some other specific examples of mediation could be environmental mediation, which began in USA, or medical mediation for issues arising in the medical arena, real estate mediation, online mediation you have just heard, e-mediation or online mediation, which these days are done with the help of AI, like whatever mediation, e-mediation happens over platforms such as Amazon or social media platforms, those are done with the help of AI. That's called e-mediation. International mediation is very different. It has it has more to do with the political or the politics, global politics. International mediation, like United Nations offering, or Secretary General of the United Nations offering himself herself as a mediator in regards to Israel-Palestine conflict, or as regards to Indo-Pak Kashmir dispute. So that's UN mediation. So that's an altogether different arena that has more to do with the politics and international relation, diplomacy, etc. There's another very big term evolving these days that's called intercultural mediation. So intercultural mediator are basically experts in understanding the language, the cultural context of the mediation, especially when mediation happens between two parties belonging to two different cultures, like one Indian and another one belonging to Arab. The cultural and the mediator himself herself belonging to some different nationality from different culture. So there, intercultural mediation, especially from the point of view of setting the context and setting the environment. So some mediation service providers also provide this kind of, expert advice so far as cultural context of the mediation is concerned. Peer mediation means basically student-related disputes. Peer mediation has been institutionalized rather in US universities, especially in law schools. Like peer mediation means X and Y being both the students having differences, having disputes, and they, instead of using the grievance redressal system, use or they are prompted to use peer mediation. So your mediation cell can even think about, or you can read text, or I can provide you the text and literature of a peer mediation. So between students or between student and teacher, okay, between parents of the students and the management or the college authorities, etc. These are covered in this. And similarly, um, or mediation used in the scientific world. So these are some of the very many uses of the mediation, application of the mediation. Now, lastly, I will ask you before I end up. We have only spoken in favor of the idea and practice of mediation. Now, as I said, not everything is rosy about this process. Therefore, what do you think? What are the disadvantages or limitations of this process? Batao?
The one is that it is not binding.
Hmm? It is not.
Like it's not a binding process.
Yeah. It is. Yeah, you have rightly pointed out that it is not binding, and therefore the parties are not psychologically prepared to go for mediation, and that is why some jurisdictions like United Kingdom, some amendments have been brought into their legislations whereby it has been proposed that penalty be imposed on unwilling partner. Okay, and and the fact that within a given period, a mediation settlement agreement should be implemented. So some mechanisms have been provided to remove this weakness. But you have rightly pointed out that masses are not yet prepared, क्योंकि उनको इतना ज़्यादा कोर्ट और पुलिस और कोर्ट कचहरी उन लोगों ने देखा है, तो ये एक ऐसा सिस्टम which is more democratic. Of course, this is very democratic. So it will take some time. The एंड एक चीज और मैं ये बताना चाहूंगा कि जब भी आप मीडिएशन की बात करो तो लिटिगेशन को हमें पुअर लाइट में नहीं दिखाना है कि लिटिगेशन में ये इशू, इसलिए मैंने वो सब डिस्कस नहीं किया, इतना डिले है, इतना एरियर है ये आप, क्योंकि कोई भी सिस्टम अगर अपने आप में इवॉल्व करना चाह रहा है then it has to offer its own strength. Like while I am arguing with you and debating with you, I should not go personal and should say you are this and you are that. I should rather offer my strength so that the masses can buy me, buy my uh, by what I am offering. So therefore our focus should be on improvising, improving this particular system of dispute resolution called mediation. It's something which is very remarkable. It speaks high of the society as well. In a society where people are more interested in mediating their disputes out, then it reflects on their culture, on their democratic values. Okay. So therefore, this is how this area can develop. Of course, you have rightly pointed out it is not binding, but something is being done. For example, mediation being done in good faith, that clause is being developed, whereby the parties must commit themselves to mediation process and participate in the process in good faith. If they have, unreasonable grounds to refuse, then cost can be imposed. So this is how this bindingness is being enhanced. So let's see what our new act will do in this regard. But what is the most crucial weakness? The most crucial weakness of mediation is that it is viewed as a sign of weakness. It is not. It's like कि जब आपसे पूछा जाए कि आप मीडिएशन जाना चाहते हो तो बहुत समय एक पार्टी पहले कहने से हेजिटेट करेगा. I don't want to participate in that. I don't want to because that is taken as a sign of weakness. Okay. Or maybe you recognize the fact that the other side is quite dominant, resourceful, more resourceful. So, but as I said, the culture needs to change. It is in fact, practically speaking, when it is seen as a sign of weakness. That's why the court role is very important while telling the parties go and participate in the process. Now, another weakness is that there can be a scenario when additional cost you will have to bear if the mediation remains unsuccessful. Another very vital issue or problem with mediation that there is a lack of precedent. Like in the judiciary, courts, judicial pronouncements go on to constitute a corpus or a body of judicial precedents. But here we do not have. But this new act also envisages creation of Mediation Council of India. And there it is, because mediation is also confidential, so it is likely that they will maintain a database for all such reported mediation cases where the parties gave the consent that gave the consent in terms of making things unconfidential or making things known to the public at large. So in some cases, it is likely to be reported as well. So that we have to see. But of course, there is a huge amount of problems so far as precedent is concerned. In mediation, the mediated outcome does not create any sort of precedent. So that is the problem. And then you have many parties exploring mediation in order to find out the strength and weakness of the other side. So it is described as mediation then gets described as opportunity for fishing expedition. जैसे नहीं आप किसी तालाब में आप मछली मारने के लिए बहुत देर तक बैठे हो, कुछ ना कुछ मिल जाएगा टाइप से. So that is fishing expedition. That is there's a likelihood that unwilling party or reluctant party will use this forum merely as a tool for gathering information of the other side. But uh, but the most important disadvantage or limitation of this process is the social apprehension about privatization of justice. What transpires, what happens inside the mediation chamber is nobody's concern. In the name of confidentiality, and with no precedent being set, anything can be compromised, anything can be agreed on. So, and the poor people, it is said the social anthropologists and sociologists, they are critiquing this process, saying this is amounting to privatization of justice. But uh, but that has some merits, but this is not entirely true. Okay, we have to see, you have to read literature to find out how much this claim is valid. Okay, and the other one disadvantage is enforcement issues. There are enforcement issues, especially in a country like India, where people understand law only in terms of court action and police action. And there's going to be a lot of issues so far as enforcing the mediated settlement agreement is concerned. So this area is going to be super exciting in the next 2-3 years. We are going to have cases also on all the aspects, on all the principles, where party alleging that some principles or one principle or this principle, that principle is too compromised. Okay, so we are going to have an interesting time so far as the mediation in this country is concerned. So with this, I wind up my speaking session. And if you have any query, you can raise it now.
So we have few questions in the chat box.
Any question you have, I can address that. Yes.
So you said in the AFCON's case, in the AFCON's case, it was stated that you cannot be compelled for arbitration or conciliation.
Hmm.
So what if in a contract there is a clause for arbitration? Like Indian Contract Act Section 28 also mentions that if there is a clause for arbitration, you can go for it.
So what's the question?
So you said that in AFCON's case was said that you cannot be compelled to go for arbitration.
Yeah, so of course, like under Section 89, a party approaching the court telling the party, would you like to explore arbitration? Party refusing, okay, that he or she doesn't want. Court cannot compel. Arbitration is a more intrusive process, you know. So therefore, but it is found, if the other side complains, me lord, have a look, there is an arbitration agreement um, between the parties. Okay. So in this situation, the court will ask the party to go for mediation because there is an arbitration agreement existing. Similar is the case with conciliation. But with respect to mediation, the party can be compelled to participate. Okay. So either party cannot refuse to go for mediation simply because either that party doesn't want mediation. So participation becomes mandatory only in terms of participation, that is mandatory, but actual settling at the mediation before the mediator, that is entirely in the hand of the party concerned. Is that clear?
Yes, sir. Thank you, sir.
So we have a question from Sumit Dahia. The question is,
Anyone else?
sir, can you hear me?
I can hear you, but your voice is very low.
Oh, sorry.
Yes, I can hear you.
Sir, we have a question from Sumit Dahia. The
Hmm.
question is, does geographical and cultural factors also consider in the neutrality?
No, it's a lot of literature is written on that aspect. Okay, interesting literature. Like while I was reading some literature, it said uh, that in Japan, eye contact is seen as sign of dominance. So if X is making eye contact with Y and not, you know, mm, bending his head down, like when you bend your head down a little, it means you are also non-verbally showing your respect to the other side. So the cultural context, mediation has to understood in a given culture, especially in international mediation, intercultural mediation. It becomes very crucial. So, uh, so that is why body language also assumes a critical role so far as mediation is concerned, especially where the parties belong to different geographies or different countries or different cultures. So, like in USA, the people there are very assertive. They mostly talk in terms of their own individual rights. Okay. That may be taken, that may not be taken as good so far as we the Indians are concerned. So, so therefore, uh, these things are taken note of. That's why intercultural mediation will also be picking up in the coming years. Yes. Anyone else? Does that satisfy you, Sumit Daya? Is that clear?
Yes, sir, it is clear. Thank you, sir.
Okay.
So the next question is from Devanshi. The question is the scope of mediation in international conflicts pertaining to
What?
international
Just hold
scope
on.
of mediation in international conflicts.
Uh,
It's pertaining to international trade and businesses and maritime laws, etc.
yes. The application of that or the cost.
Yes, the application of mediation in international conflicts.
So international conflict, when we say that like UN mediation, we are not talking of, but the other arena under international law where mediation is often used is often used in World Trade Organization, or you can explore other organizations. There are hundreds of organizations. Either those organizations are affiliated to UN, United Nations, or some regional board organizations like European Union. So you have, for example, WIPO, World Intellectual Property Organization, and they actively promote use of mediation. But the basic understanding of mediation remains the same. The principles remain the same everywhere. Okay. The process can be customized a little bit, but the fundamental principles remain the same. So, like, so far as her question is concerned, where it is used under international system, so it is used by WIPO, World Intellectual Property Organization, in WTO, World Trade Organization, even the dispute resolution clause these days between two countries, insofar as trade agreements are concerned, they usually contain mediation clause, because now you have UN, United Nations backed, United Nations supported and backed international convention on mediation, that is called Singapore Convention on Mediation. That is more in the that's in the area of resolving international commercial disputes. Okay. So in Singapore, India is also party to that convention. It has now come into force, Singapore Convention, and that is why Singapore Convention on Mediation actually prompted the government of India to come up with this new mediation act. So in 2018, Singapore Convention on Mediation was brought about, signed and brought about. So so there you have a full-fledged international law covering this vast domain of mediation. So it has systemic application everywhere, in international organizations, in bilateral agreement, parties opting for mediation clause. Okay, so that's why mediation service providers will also be picked up. Already we have many mediation service, internationally recognized mediation service providers. Uh, and you as a law student, first year law student, can even explore ICC Paris mediation competition, mediation moot, mediation, which is organized annually in the month of January or February. And this year itself, an Indian team from Nalsar won that prestigious title. It is the oldest mediation competition, so you can explore that. So there are many agencies, there are many places, many organizations where the mediation is frequently used. Okay, student, any other question?
No more questions, sir.
Okay,
Thank you so much, sir. That was a very informative session. Now,
okay,
everyone,
fine.
could you please switch on the video? We will now take a group photo. Everyone, please switch on the video.
I've taken the screenshot as well.
Okay. Sure. With this, we have come to the end of this really insightful and illuminating session. I take this opportunity to give away the vote of thanks. I would firstly like to thank our speaker, Dr. Akshish Kumar sir, for taking time out and giving us comprehensive knowledge and understanding of arbitration. Thank you so much, sir.
Okay,
I, I would further like to thank our teachers, Dr. Ashutosh Mishra and Dr. Rohit Munga, for always supporting one of you for such a sincere and interactive audience. I hope you all gain